Well, this is Mahfuzul Ihsan. My student ID is 20072736, and here my student ID card is. Well, I am here as an advisor to represent my client Ethical in arbitrary proceedings against Spain by describing breaches of Spain-Albanian bilateral investment treaties. Etico is an Albanian company that deals in electric telecommunications. In 2019, Etico was appointed by Spain to develop a new project that will enhance the current telecommunication system of Spain. After entering into a contract with the government, Etico started doing work. However, Etico caused huge damage to the telecommunication system in Spain, due to which the government of Spain terminated the contract as they had to bear immense losses. In this regard, the discussion is directed towards the evaluation of legal issues and analyzing the conclusion from the client's point of view. Well, due to the severe damages, the government of Spain terminated the contract despite several efforts for renegotiations. The Spanish government failed to provide support to Ethicop even after the excessive effort and investment of the company. The first legal issue identified in the case of the Kingdom of Spain and Ethicop is the Full Protection Treaty. According to Article 3 of WIT 2003, investment made by that entity should be completely protected and secure. However, the government of Spain terminated the contract with Eticorp for the enhancement of the telecommunication system without the knowledge of the company's investors, along with its stakeholders and employees. Well, the investment and funds provided by investors of Eticorp were not protected and secured, and the government of Spain failed to render any protection to Eticorp, which raised huge issues. Besides this, several residents protested on a large level against Etico, and the company had no protection. Moreover, Article 3 of WIT 2003 states that there shall be fair and equitable treatment for the investors, and the party should have complete security. Article 3 is considered a strict and compulsory function as per which treaty investment is considered an agreement which is done internationally by identifying terms and conditions for the purpose of making private investment by companies or government of one state into a different state. In treaty investment, no party should be subjected to unreasonable or discriminatory harm, and the interest of the parties should be kept in mind for rendering full protection. In the light of this, it has been examined that the termination of the contract by the government of Spain and the negligence in addressing the protection of Eticorp and its investors in the country should be subjected to a breach. Despite the huge efforts of Eticorp in facilitating renegotiations, the Spanish government ignored the protection right of Eticorp as permit and failed to renegotiate. Hence, it has been evaluated that the government of Spain could have opted for the renegotiation option instead of terminating the intercontract and disrupting the uh, management and employees of Eticorp as per Article 3 of BIT 2003. The second legal issue identified in the case of the Spanish government and Ethicop is linked with expropriations. According to Article 5 of WIT 2003, investment made by a party in a country or state should not be expropriated or used for personal uses and for discriminatory causes. The compensation rate will be established effectively, and there shall be no delays in providing compensation to the parties. Moreover, the evaluation of investment is also facilitated for increasing safety for the investor parties. The government of Spain is majorly uh, concerned about barriers in economic development and wastage of resources rather than the expropriation. In the case of Philip Morris and Australia, Australia enjoyed all the benefits of ISDS, and the case uh, got highly famous because of the statement of a huge compensation fee for the loss. However, the case should have focused on protecting the investors by providing full security and prohibiting expropriations. Besides this, the investors have full right to appeal to judicial authority for the valuation of investments and acquiring compensation as per the WAIT 2003. The conflict between parties should be initially solved with the help of diplomatic channels. However, as per Article 10 of WAIT, uh, if the dispute settlement is not finalized and settled within the duration of 6 months, the case is transferred to the arbitral tribunal for settlement. Furthermore, in the case of the government of Spain, the Ethicrop, the termination of the contract was not mutual, and the Ethicrop was not in favor of accepting the decision of the Spanish government. There is the absence of arbitration in this case, which is a major issue. Moreover, both the parties should have opted for arbitration to resolve their dispute, which would have enabled finding a favorable decisions for both the parties. By doing this, the interest of stakeholders, personnel, and investors could be protected without causing any harm. As per the analysis of these issues, it has been identified that there is a lack of arbitration in the case which resulted in harm to the stakeholders and investors of ATCO. The rights of investors should have been secured by the Kingdom of Spain. It has been evaluated that both Ethicop and the Spanish government should have agreed on arbitration to settle the differences. Besides besides this, Ethicop initiated renegotiation and also made big investment due to which FET and MFT, as stated in the bid, should have been issued in this case. According to the International Center for Settlement of Investment Dispute (ICSID), the termination of the contract or failure to meet the required standards should be aligned with the interest of both parties by following specific measures. The motive of ICSID is to secure the investors and protect their rights. For instance, the dispute settlement in MTD versus Chile was in favor of the rights of investors, and the FET rights were protected. The issues of expropriation and discriminations were denied. In the case of Spain and Ethicop, negligence towards renegotiations is considered vague and irrelevant, and it depicted the ignorance of private investors involved with Ethicop, as the company had made huge investment. In the case of Spanish government, Ethicop is most favored nation statement as stated under Article 4 of BAIT 2003. In the case of the Spanish government and Ethicop, the Spanish government failed to protect the interest of the investors and even the third-party investors. As examined from the case, the government of Spain was highly ignorant of the third-party investors of Ethicop. Not only investors, but the Spanish government also failed to protect the interest of the employees and other stakeholders who were responsible for enhancing the telecommunication system and the telecommunication system. And the government of Spain deported the management and personnel of ET Corp and allotted the work to their own employees, which is considered a huge neglect of MFT as per WIT 2003. The government was more favorable to its own investors and stakeholders and ignored the third party or state investors, and there was high discrimination and failure to provide fit to ethical. In Article 4 of WIT 2003, it has been stated that state investors or third party investors shall be treated equally by avoiding any sort of unfairness or biasness. According to MFT, no party or investor should be provided with special treatment, and the parties should be treated by avoiding partiality. Besides this, the clause states that no extra privilege should be provided to any party or investor. For instance, in the case of Ukraine and Levaya, there has been no special treatment provided to investors of Ukraine, and Ukraine had to bear all the problems instead of their investors. Therefore, the appointment of uh, Spanish personnel to work on telecommunication project and reporting of senior management have been considered an issue of MFT. Besides this, the police in Spain are not bothered about protecting ethnic during protest. This is also an issue of MFT. Uh, to conclude, it has been examined that the government of Spain has violated the breach stated under WIT 2003 and has failed to protect the interest of Ethico. The Spanish government is subjected to indulge in discrimination and termination of contract and has not followed the clause of MFT by appointing its own personnel. As per Article 4, no protection and security have been rendered to Ethiopia, and even the police neglected to protect the company during protest. Besides this, no favorable treatment has been provided to Ethiopia as per the clause of MFT. Thus, it is respectfully submitted to the tribunal that Spain has not breached the provisions of WIT 2003. That's all about my presentation. Thank you.